Good afternoon. Welcome to the EJF Learning Series. I'm your host, Sarah Keller, the Director of Community Management at EJF. This session is being recorded. After the presentation, we will allow a brief period of time for Q&A. And today we have Brian Fellner, founder of Fellner Legal Services. Brian is presenting on board elections, association meetings, and much more. Without further ado, I will turn things over to Brian. Brian.
Hi, thank you, Sarah, and welcome to everybody. We are going to talk kind of very broadly about a number of topics, best practices, and things that you confront as a community association board member. I like to think and hope that we are going to cover, basic foundational topics and also some things that are frequently asked questions. My understanding is we're going to do a Q&A towards the end, so hopefully we'll kind of hold the questions as we go through, and maybe I'll even cover your topic or answer your question before we get to that point. So if we want to go ahead and move forward to the first slide. Okay, so a couple of really important things to know right off the bat, and one thing that I like to tell clients, people who are talking about their attorney or anything else. So we're talking about the legal framework, and first of all, a board will often say, is this legal? And they'll ask the manager, typically, and especially well-seasoned managers from EJF will say, you should ask your attorney that question. But the attorney is going to answer it in a couple of different fashions. That's more than one question at once. Number one is, do our documents allow for it, right? And corollary to that, do our documents to allow for it permissibly under relevant law? So we talk a lot about the hierarchy of documents, and in this instance, federal law and state law both trump your documents. So if your documents say, for instance, you can discriminate against someone, and there are old documents that absolutely do say that, that is illegal. That is against the law. So the fact that the documents allow for it doesn't necessarily make it legal. That's question one. Two is there a statute that allows or prohibits this? Maybe your documents are silent on this question. A lot of these election things come out of best practices, common usage, or other things like that, or assumptions that are made by the law or the drafters of your bylaws or declaration. So if they are silent or if they are ambiguous, is there a statute that says either yes or no very explicitly? Three is, has a court issued a binding case dictating the outcome here? All right. So if we're located in DC, the Court of Appeals is our main question. If we're located in Maryland, the Supreme Court of Maryland or the Appellate Court of Maryland would both be binding if they have spoken on this, and as well the Virginia Supreme Court. So there are courts that can tell us that we can look and say, all right, can we do this? Is it allowed? Even if our documents don't say one way or the other, there may be something that we should know. And if none of the above, then you're asking your attorney's opinion. You're saying, what is the your opinion on what would take place if we go forward in this fashion? How would this work out? So this comes up in terms of what boards decide to do, as well as how elections are conducted. So we can go forward. All right. So the requirements of the board come from two very specific places. Number one, your relevant statute. I'm going to reference the DC Condo Act today, but I will touch on especially Maryland differences at times. If you are a DC HOA, and there are a few and a growing number of those, there is a draft version of the DC HOA Act, but it does not exist as law yet. So you are governed by a combination of common law and corporate law. And then, of course, we will talk about many common bylaw provisions regarding your board of directors. So next slide. So DC Condo Act requirements. What do you have to do and what is required by law? The executive board means the executive and administrative entity, names are all different, and you're going to act on behalf of the association. Any lack of compliance, and this is a big one, any lack of compliance with this chapter or the condominium instruments should be grounds for an action to recover damages or injunctive relief. When you're a board member, if you violate these rules and these laws, unit owners can bring an action to fix that for injunctive relief or for damages. And this is one of the most important things we'll talk about, the decisions and actions of the Unit Owners Association and its board are reviewed by a court using the business judgment standard. What does that mean? That means that if the association's board acts, if you're going through your dispute resolution process, if you're setting forth a plan for elections, if you're setting out guidelines or rules and regulations, as long as they aren't otherwise in violation of a different law, a court won't go in and second guess them if you have exercised your judgment. They won't go in and say, look, that seemed like a nuisance and you voted that it wasn't really a nuisance, and so I'm going to slap you on the wrist for that. A court will stand back and say, you, the board, were exercising your executive function, and thus I'm not going to go in and second guess you. So that thing up above that we talked about, where you can be on the hook for damages or injunctive relief, you're protected as long as you're using your processes. So we're going to go forward now and talk about a little bit what those processes are. Common bylaw provisions. Now, this is a big one when you're talking about choosing your board, choosing your officers, and it's one of the ones that gets sort of misstated or misunderstood very frequently. You don't have to raise your hand right now, but think if you've been a part of any of a board or anything else where you said, I was elected the president by the owners. That is almost certainly not the case. In almost every single set of bylaws or documents I read, the directors themselves are elected by the owners, and then the officers are selected by and from that set of board members. Very important distinction. So the board itself is an executive function, as we talked about. It's usually made up of 3, 5, or 7 members. And if you take a look at bullet point number 3, you'll see there are odd number of directors. Very, very important to have an odd number of directors because you're going to have disagreements from time to time. The board will not always be unanimous. You want to have an outcome that is determined by vote. You don't want to have a 2-2 tie or a 4-4 tie or a 3-3 tie because that bogs down your ability to function. So typically the board is chosen by the developer up until the sale of 75% of the units. 2 years after the sale of the first unit, something else like that. There's a triggering event in there. The Condo Act has one. And then they will be elected by unit owners at an annual meeting where quorum is met. Three big points there. Number one, your unit owners are going to vote to select their board members. And so you get an opportunity, and it's one of the things that owners really often leave on the table. And it's one of the greatest powers that they actually have as unit owners is to select the board that is going to make these decisions on a day-to-day basis. Your documents almost certainly have a provision for an annual meeting. Do this every year. Now, sometimes the terms can be multiple years or staggered, but the annual meeting is going to take place every year. And in order to meet that, in order to elect those board members, you have to have an election where quorum exists. That will be a certain percentage of your unit owners. I've seen it as low as 10 or 15%, as high as 50%, and sometimes that is a very demanding thing. One good note, one thing to keep in mind is that you can make quorum with proxies, and you can make quorums with proxies that just say, you can mark me as present for the purpose of quorum. So people don't even have to vote necessarily to get there. You can have these proxies that say, mark me present. Now suddenly we have enough unit owners attending in person or by proxy. That's almost always what it says. And it will tell you then that the majority of the voters there select your board. Now you have a validly elected board, and so you can stand behind all of the things, all of the actions that they are taking on your behalf. I mentioned briefly the staggered terms. Staggered terms exist, to make sure that there is fluidity among the board. There are options for people to run for open seats, and also to provide for at least some maintenance of institutional knowledge. You don't want to have, ideally, all 3 or all 5 new board members in a given year because people don't know necessarily where even the files are kept or who the best contacted management is or who your insurance broker is or a number of other things. So that stagger of the board members is very, very important. Sometimes over the course of time, you can lose track of that stagger, right? You've had the same 3 board members for a while. And no one really can remember or trace all the way back to who came on the board first and whose seat is up for election this year. If and when that happens, my recommendation is always, and your documents sometimes do even provide for this, go back to that first annual meeting the way that you would select all of your board members. So for instance, if you have a 5-member board, the top 3 vote getters get the 2-year terms, the next 2 vote getters get a 1-year term, and they next year will be up for re-election for 2-year terms. Bang, you have your stagger back in place. Board members typically can only be removed by a vote of unit owners. So once you've been elected by the unit owners, you can't be taken out just by your colleagues there on the board. It has to go back to the owners to remove you. And the board typically fills vacancies on the board themselves until there is an opportunity to elect someone to that vacancy. Next slide. Okay. So board procedures. We've gone through the process. We've elected our board. And now the first thing you want to do after that is hold your organizational meeting and vote on your officers. Notice I've said the board is separate from, or the directors are separate from the officers. Typical officerships are president, vice president, secretary, treasurer. A couple of common provisions are: number one, the president almost always has to be a board member, and the vice president almost always has to be a board member. Secretary and treasurer do not necessarily have to be board members. Just take a close look at your documents and see. And I call on fellow professionals, especially folks who are a retired accountant, retired attorneys, things like that, who have some experience with either taking and keeping of minutes and or taking and keeping your budget, who may want to volunteer for just that job. They don't want to come and be responsible and have the votes and everything else like that, but they're willing to wear that hat for you. It's a great opportunity to seize willing volunteers from your community and have them work for you. So a top thing that we recommend is to obtain board training. Check today, right? Mission accomplished. Do things like
Thank
this.
you, Brian.
See it. Vendors or trusted resources is bullet point number 3 down there. EJF, obviously, and I hope myself as well are both vendors and trusted resources who you can go and seek out opportunities to learn. You're not necessarily reinventing the wheel, and you don't want to have to. You want to stand on the shoulders of all the people who've already done this, and that way you can easily knock out a lot of tasks. CAI, Community Association Institute, does put out a number of educational materials. The CCOC, which is located in Montgomery County, and its sister organization in Prince George's County in Maryland, both put out educational and training materials as well. Board procedures. Once you've got your board elected, you've held your organizational meeting, and you have your officers in place, you want to figure out how you're going to work with your management company. First of all, if you're self-managed, you want to know what your secretary and treasurer are going to do. They're going to have really, really important jobs in terms of taking those minutes, having them ready for the next meeting, creating the meeting notice of meeting and agenda, and also for the approval of meeting minutes from the prior meeting. Your treasurer, the same way, is going to want to have your annual budget and then to have a financial report ready for each of your meetings. If you have a professional management company, you can delegate. Your bylaws will say that you can delegate certain of these tasks to them. You want to absolutely set a liaison. This is important when you're working with any of your vendors, whether it be your attorney, your snow removal company, your insurance broker, or your management company. You want to tell them clearly, the person from our board who's going to reach out to you is X, is this person right there. And so when you hear from them, you can assume that is the board's wishes. We've talked and we've sent them to you to talk to you. Having an email thread where all 5 board members are chiming in and instructing and pulling your manager or your insurance broker or God forbid, the snow removal person in different directions is never a good situation. So delegate that liaison. Hold regular meetings. This is very, very important to do. Both the DC Act and both Maryland statutes on the topic talk about having open meetings. There's a specific subset of the Maryland legislation called the Open Meetings Act. So when your board meets, it has to be open and available for unit owners to attend. They have to be able to observe. They do not get to chime in and comment and take you off the rails or anything else like that. But there should be an opportunity for them to speak and be heard, what we refer to as unit owner forum at the end of that. You can put reasonable restrictions on it. If you've got a long-winded attorney who lives in your neighborhood or something else like that, who you're concerned may hijack it, you can put reasonable restrictions and time limits on it. However, your unit owners can and should be heard from. And so you have to have that take place. Holding regular meetings that are open to your unit owners and keeping good meeting minutes are the best things you can possibly do. If you take nothing else away from any of what else we're discussing, when you are having those meetings, you take the meeting minutes, and at the next meeting, you ratify those minutes or make sure you have any changes voted on, and then put them somewhere. Google Documents is fine. We're all using digital things a lot more now. Dropbox, wherever they are, but to be able to have them and distribute them and go back and say, we talked about it earlier, the business judgment rule, that's a really important way to support that you exercised your judgment, is to go back and say, well, on March 21st of 2025, the board voted and decided that we were going to pass that particular set of guidelines, or we decided to impose a violation and a fine based on the information that was provided to us. Holding those meetings and preserving those meeting minutes is extremely important. Next slide.
Just a quick thing. When you say regular meetings, I feel like sometimes this gets a little, I don't know. I've seen boards go back and forth about what they deem regular, especially if their governing documents don't have it stipulated on how often they meet. So is there a general rule of thumb or a requirement?
That's an outstanding question. There is a bit of a sliding scale. Monthly meeting minutes is what I would tell you, especially if you're a condominium or something that has regular business going on. If you're a smaller association, bi-monthly, I would absolutely not go any lower than quarterly per year, even if you are a small association or you don't have a whole lot of things going on, or you have a low number of units. I would not recommend going lower than quarterly. One other good tip to keep in mind is you do have to send out those notices of meetings in advance. You have to tell the owners when and where you're going to meet. You can comply with that by sending the entire annual schedule at the beginning of the year. We're going to meet the second Tuesday of every month at 7 p.m. in the clubhouse and use this Zoom link. Boom, done. You've complied with the statute all the way for the entire year. And as long as you do that and you don't change it or anything else, every single one of those meetings is validly noticed and you're good to go.
Excellent. One other quick thing, when setting the agenda, where should you put the Q&A for the owners?
We refer to it as unit owner forum because it's
Unit owner forum, sorry.
They can be heard. You don't necessarily, this is a good tip, and it's a good distinction. You don't necessarily have to solve their entire problem just because they come and talk to you and raise an issue and say, you know what, Joe next door, I hate being able to see his flower bed all the time, and I really wish he would move it back behind the house. You don't have to fix that day. He gets to air that thing and you say, all right, we're going to take it under advisement. And it's a good way to connect with your owners. I recommend putting it at the very end. Accomplish all your business first, and then hear from your owners. There's nothing wrong with that. The only time that would change is if at that meeting you're going to adopt a certain policy or something that you've put out, then you want to hear from people on it in advance before you take that vote. Right. So next we're going to move into kind of part two of our discussion, and this is powers and duties of the board. So we'll go ahead and move forward. Right. This is right from the DC Condo Act. What you can do, and I'm going to point to subparagraph A first of all, and this says, except to the extent explicitly prohibited by your condo instruments. Now, this is a distinction between DC and Maryland to a certain extent. The DC Condo Act is extremely deferential to your documents. And the DC Court of Appeals has upheld all of this. And it said, look, that's what it says. That's what the statute says. So if your docs say something otherwise, that goes first on this particular topic. Maryland does that much less frequently. Maryland says a lot of their things are done by statute, and your docs can't violate it. So keep that in mind depending on where you're based, where you're located. But so the association has the power to adopt, amend bylaws or their rules, adopt and amend a budget. Most important annual function of the board. Put out that budget. Work with your manager. Pull it together ahead of time. Know what date your bylaws say that the budget has to go out. Know what your fiscal year is. 80 something percent of the associations I work with use the calendar year, right? So on January 1st, your assessments potentially will change. But that's not always true. And so make sure that you know that or aware of it if that is not the way that your association functions. Power to hire and discharge management, institute and defend litigation, the power to make a contract or incur liability. So this is really, really important. Your association functions as a business. It's tricky sometimes, right? You're also dealing with your neighbors. You're also dealing with people that you know, friends, colleagues, people that you see out walking the dog or out for a jog or anything else like that. But at the end of the day, when you are sitting on the board, you're a fiduciary and you are a business. You are functioning as a business and you have all of these powers. So make sure that you are being clear, transparent, and following good procedures when you utilize those. Next slide. Right. And we're going to run through a couple of these, but I like these highlights because they're very important as to what the association has available to it. First of all, you can impose charges for use specifically of the common elements and for any service that's provided to the unit owners. It's a pretty broad one, right? It's a little broader and it's a little bit less onerous than what takes place in Maryland. So if there's a charge, if there's something else that is incurring a cost for owners on the common elements, you have the ability to pass that through to your unit owners. You can impose late payment for an assessment, and here's a big one, after notice and opportunity to be heard, you can levy a reasonable fine for violation of the condominium instruments. Okay? Notice and opportunity to be heard. I strongly, strongly recommend to every single one of my clients to have a written dispute resolution policy that the board adopts. If you, after you've done the three things we checked off earlier, after you've got your liaison, you know who's talking to management, you've got your retired CPA who you roped in and is going to do your treasurer work for you. Now go adopt a dispute resolution policy. This is what will take place if and when we get a complaint. And it has to have a couple of things. Number one, you have to tell the owner when they've alleged to commit a violation, what they've done wrong, what the rule that they are violating is, a time period in which they can correct it, and if they do all of those things on the first notice, that's it. That's the end. There's no immediately jumping to fine. There's nothing else like that. Everybody gets one bite at the apple to say, all right, we told you to correct it, you corrected it, end of procedure. Boards sometimes stumble over this. I have other management companies who sometimes stumble over this and say, let's jump right into the fine or anything else like that. And the simple fact is, your dispute resolution procedure should say, we're going to tell you once what you did wrong, and you will stop it during this time period, and that will be the end of the whole thing. Second, right there, it says the opportunity to be heard. A hearing will, if it takes place, if you need to move forward after that first notice, should take place in executive session. So most of your board meetings are going to be an open session. You're going to take your meeting minutes, all the things that we have talked about up until now. However, there are seven statutory exemptions to that for why you can go into executive session. And one of them is to hold these hearings, to hear about violations. And so in executive session and off the regular record, off your regular meeting minutes, anyone who's complaining can present all of their evidence. Anyone who has been complained against can present all of their evidence. And then at that time, the board should vote. And that's right back where we talked about the business judgment rule. The board should vote one way or the other. This is the best thing you can possibly do when you get a complaint. I had this discussion yesterday with a client who said, we're not really sure if this is a violation or not. The owner is complaining, the one owner is complaining, the other one has said some stuff to us that we think maybe supports their claim that it's not really a violation at all. The worst thing you can do is nothing. The worst thing you can do is nothing, because at that point, both owners may have a complaint against you. if you go through this process and you have a dispute resolution procedure, and then you vote, whether you vote yes, we find a violation, or no, we do not find a violation, the business judgment rule now protects you, and a judge will not go in and second guess you. Say, man, if they're really that loud and that dog is really barking that frequently, then yes, this is definitely a nuisance. They won't do that. By law, they cannot do that. So use that dispute resolution policy and procedure. Very important. The power to impose a reasonable charge for resale package. That typically is handled by your management company. Power to provide for indemnification of officers or the executive board and have liability insurance. This is something you should talk about with your insurance professional, but you should have what's called D&O, or directors and officers insurance, that covers you for anything that an owner or anybody really says that you did wrong in the course of the exercise of your duties as a board member. Sometimes people are disincentivized to act or to run for the board or to participate. They say, I don't want to put my neck out on the line. And this is right there to tell you that if you are acting even under the color of your authority under the bylaws, then you should be protected by both the association itself and by your directors and officers insurance policy.
One quick thing to just add, your insurance agent is more than happy to come to a board meeting and speak with you about your policy and go over it in an open setting. And I highly encourage you to do this because it doesn't cost you anything. And it's a good way to get direct and specific information that is for your individual association.
Absolutely. And 14A is very important for a lot of us, especially condo boards in DC. But the power to reasonably restrict leasing of the residential units. So the one really big important thing to notice in there is when you put forth a leasing policy, a new leasing policy, anybody who's already leasing is grandfathered into whatever they're doing. You cannot put a stop to a current lease or a existing lease by passing a policy during the pendency of that lease. They get to at least complete that leasehold itself, and they can continue to lease under the same rules until either they move back in or sell it, right? So if you've got somebody who's using it in a certain fashion that you do not like and you wish to create this policy that changes that for all future residents and owners and everybody else, that owner right there, as long as they keep doing it the same way they were, is grandfathered in until they either move back in or sell it. Board wanted to know. Next slide. Right. So some common bylaw provisions. So we've done a bunch of stuff now, right? We've elected the board. We've selected our officers. We know how we're operating and how we're going through each of our meetings. Generally, we know when they're taking place, or we've put out our entire annual schedule, and that way, we know when each and every one of them is taking place, and our unit owners do as well. And we've talked about resolving disputes, which is a really, really important one. Here are some other things that the association board is typically called on to do and or is given the authority to do. One, restrict leasing. We just talked about this. And it's a very controversial one. It's a very important one. A few things that you can do. Number one, create a policy. If your bylaws say something fairly broad, like no transient use or anything else like that, and you want to interpret that, the board want to interpret that as no short-term rentals or Airbnb type rentals, you probably have the ability in those documents to create that policy. So we talked about hierarchy of documents just a little bit earlier. Federal law, state law, your governing documents, which are your declaration of bylaws, and then any board policy or resolution. So it has to be granted to the board's discretion itself, that power, and it has to not violate any of the stuff that is up above it. However, you can do all of these things. So put restrictions on leasing is a really big one. And not only do I recommend to clients to pass a leasing policy or a leasing resolution, but also you can create a form lease addendum that you require unit owners to turn in. So Sarah's nodding her head along because she knows this is very helpful in the enforcement context and just to keep a track on some of these things. In DC, if you're renting out your unit, first of all, you're required to have a basic business license. So you can confirm that. You can confirm that. Two, you can make sure that you have contact information for in case of emergencies. If you need to get in, do a water shut off, something else like that, you have somebody else that you can reach out to. It is useful to confirm that it is not being used as a transient or hotel or Airbnb short-term rental type place if that is prohibited. Then if you've got that lease in place, you've got that lease addendum on file with your office, then you know that is not taking place. And it can be useful in the collections context as well if that owner stops paying.
Mm.
Uh,
The thing that I like to see added is the insurance requirement, because everyone's supposed to have insurance in DC.
Absolutely. Not only are they're supposed to have a couple of different types of insurance, but they're supposed to have that HO6 policy, which covers two different things. Number one, it covers all their three different things, really. I'm going to make three different separations. Number one, it covers all their belongings, which I don't usually list because we're not worried about it one way or the other. They got to replace their stuff. We know that for a fact. Two, it covers any betterments or improvements that they have made to the unit. And that does matter to us because your master insurance policy is going to bring the condo unit back to the way that it was prior to that incident, exclusive of betterments or improvements or at builder grade, the way that it was turned over to them at the original sale. So if they put in marble floors or if they put in crystal chandeliers or if they put in any other upgrades like that, you're not paying for that. And they are going to ask you to. They may well ask you to and say, hey, put back my beautiful property exactly the way it was with all the gold-plated fixtures and everything else that were in there. And you, the association, are going to say, no, no, no. Where is your HO6 policy? It covers that. It also should cover their portion of the deductible. In DC, $5,000 gets passed through to the source unit owner for any insurable event. In Maryland, it's gone up to 10. In either case, a lot of people don't have 5 or 10 grand laying around to just stroke that check. However, if they have an HO6 policy in place, then that policy does that for them. So other things you typically are authorized to do, prohibit nuisance. The sentence I say most frequently is nuisance is inherently subjective. So what is a nuisance to one person is not a nuisance to the other. Your board may not be unanimous on whether or not it is a nuisance. I'm going to take you back to what I talked about with the dispute resolution policy and the business judgment rule. Go through all of those processes, hear all of the evidence, and then take a vote and make sure that your board has an odd number of people on it so that that vote decides the issue one way or the other. Because nuisance is inherently subjective. Look for consensus where possible, but this is one where people are going to disagree. You're just going to have to vote, and the majority is going to carry it. You have the ability to regulate parking. Look closely at your documents when you are dealing with parking because it may say one way or the other whether parking is pertinent to the unit, deeded separately, assigned by the board, or first come, first served. And if the documents say any of those things, it's very, very difficult for the board by themselves to change that. You typically have to comply with what the bylaws say among those different ways that it is legally owned and possessed. Now, you can put in all kinds of restrictions and different rules. You can make sure that there are things like no inoperative or junk vehicles, make sure that you are requiring registration be up and current, all those kinds of things. But the basic framework is going to come from your bylaws, and you have to comply with that. Create rules for the use of common areas. We heard earlier that you can also impose charge for certain things that take place on the common areas and enforce architectural guidelines. Your documents probably will say, here's the basic study. If you're a condo, there's not a ton of these issues. A lot of that is internal and says as long as you're not messing with the structure, you can do what you want on the inside of the property. It's just if you've got a beautiful balcony or facade or something like the photo there, you may have an architectural issue or question. But if you've got either townhouses or if you're an HOA, single family or anything else like that, you will have significant architectural board or an architectural review committee, ACC or ARC, sometimes they're referred to, and they or the board themselves are often authorized to put out guidelines. I can't recommend this strongly enough. If you have certain architectural issues that come up over and over again, put out guidelines that are objective and are easily understood, and give your unit owners or your lot owners some expectation of what they can and cannot do. Don't say we're going to review every single case, case by case. Here's an approved palette of colors for front doors. Here's an approved style of fences. Here's an approved location anywhere back behind the midline of the house, all the way back for sheds. Anything else like that, make it objective and make it foreseeable and easy to comply with for your unit owners so that they know in advance when they go to Home Depot, they're like, here's my color palette, here's what I can buy. I don't have to worry about getting in trouble and going 10 rounds with the association board. Next slide.
Comes in handy when people are looking to buy in the community.
Absolutely. All right, so I'm going to cover like a few kind of broad topics here that are useful for the board to know. So the DC Court of Appeals has weighed in, and they've said a few things that are really instructive in terms of what to know when you're exercising your board functions. And it says, although the board has broad authority to regulate the internal affairs, it's not without limit. Right? So they're going to consider number one, were you allowed to do it by the documents or the statute? Does something give you that authority? Right? That's what they're going to look for. So reasoning from first principles, go find what your authority is. And if you're not sure, go back to the list we just talked about and figure out all the things that are typically in there and look for your use restrictions, or look for that provision in the bylaws and say, here's what I'm hanging my hat on. It's right there. And by the way, don't forget to, where possible, pass a policy, pass a clarifying rule or regulation, pass some guidelines that tell owners exactly the way you're going to treat this thing so they know ahead of time. The fewer of these that bubble up all the way to you in your dispute resolution policy, the better. And then it says, except to the extent expressly prohibited by the instruments and subject to any restrictions and limitations specified herein. So number one, are you allowed to do it? And then number two, is there anything else that reins it in, or is there anything else that narrows your ability to focus on? Next slide. Now, when courts, this is the lawyer in me, right? Whenever I'm talking to clients, I start talking to them about what would happen if we litigated all the way to the Court of Appeals. Now, try not to do that. You don't want to be involved in litigation. You don't want to go all the way to the Court of Appeals. But working backwards and thinking backwards and saying, hey, here's what would work and here's what would not work is a good way to situate yourself in a way that you will succeed at some point. As you go through that process, at some point, any contentious unit owner, any issues that are bubbling up between the board or anything else like that should win if you are following these things that are going to win in the long run. And the Court of Appeals has said, when we look at the reasonableness of condo regulations, we're going to look at two things. We're going to look at number one, the substance, and two, the procedure, right? Are you putting out things that comply with our hierarchy of documents? Are you hanging your hat on something in the bylaws that says you're allowed to do this and you're allowed to regulate this? And two is the procedural aspect. Are you having regular meetings? Did you adopt this policy at one of your open meetings where you put it on the notice of meeting in advance, where unit owners were allowed to come and talk and be heard at open forum? And did you at least take their commentary under advisement? And then courts will look and see if your actions bear a relationship to the health, happiness, and enjoyment of life of various unit owners. So that's a quote right from the Court of Appeals that you can always keep in mind, kind of a North Star. Next slide. And they look for also potential discriminatory things. If you heard about or were at our FHA lesson not too long ago, then you know about the Federal Fair Housing Act, which prohibits discrimination against certain protected classes. And we talked about whether or not the procedural aspect has been followed. So we can go to the next slide. And finally, courts generally find these regulations unenforceable if you didn't follow the procedures that you were supposed to do. And I have some illustrative examples here of some things that commonly come up. You attempted to ban pets through the promulgation of a regulation, but it was invalidated because the condo documents require that the restrictions of units be implemented through amendment to the bylaws. So what is the problem here? The problem is we were doing something at the rule and regulation level, at the board rulemaking level, that the condo docs specifically say has to be a bylaw amendment. Can't violate that. That's a really good example of taking the hierarchy of documents that we were talking about and that portion from the case law and saying, all right, let's reconcile those things and make sure we're not violating what our docs say. Here's a second example. You deny the HOA is going to deny authorization to build a prefabricated home that was invalidated because the wrong entity acted on the application. So if you've got a board of directors and an an architectural review committee, make sure that you are going to the right entity and you're doing it in the right order. If your documents say, here's how we act on these applications, make sure you follow them. And the applicant was not given a timely reason timely notice of reason for denial. So you have to act on those within a certain period of time. Again, that's prescribed by your governing documents. And an assessment can be invalidated if you've got a budget and your budget goes up. We talked about having that budget meeting, telling the telling your unit owners when it's going to take place and when you're going to vote on it. One thing I didn't hammer hard enough, and I will do right now, I will correct that. Budget is a board level decision. The owners don't get to vote on it. You must be very transparent about it. You must hear from your unit owners, but at the end of the day, they've selected the board and the budget itself is a board level decision. So it says assessment invalidated where board failed to follow proper procedures. That means send out the budget in advance, hold the scheduled meeting, and then vote on it in front of the unit owners so that they could see that take place, and then make sure that they are notified far enough in advance of that increase. So for instance, if it's going to change on January 1st, make sure you tell them no later than November 1st that that's going up so that they have the opportunity to make that adjustment. But if you do all of those things, you're good to go. And a unit cannot then argue it. And that's the counter example that says it right there. You do a parking regulation, it's going to be deemed reasonable if you tell everybody we're going to talk about it, have a specific meeting on that topic, do it in front of all the owners, hear from the owners, and then vote. And it's provided for right there in the docs. So we'll go to the next slide. And we're going to go very quickly here to talk about the new Maryland rules that have come up. We can go to the next slide. But these are became effective on October 1st of this year. It says Maryland associations must now have their elections conducted by independent parties. And that's quoted because that's language right from the statute, who are not candidates and do not have a conflict of interest regarding any candidate taking part in the election. Community association managers typically can't do this. This was always sort of the understanding, or at least an understanding that was out there. It has now been codified in Maryland law. So your manager, if they are a third party, if they're, that's the wrong word. If they are a hired management company, cannot run this portion of the election. They can't be the inspectors of election. So we'll go to the next slide. Here's the definition. Independent party is a qualifying unit or lot owner. So when you bring your owners in, get some people who are going to volunteer, who are not running in the election, who aren't brother and sister, who haven't been campaigning for any of the candidates, who aren't related to any of the candidates, any of those things, who don't have any strong ties to any of the candidates. And then property management that is owned by the association. So if you've got your own independent company that does that, and there are third-party vendors and technology platforms who volunteer to do this. I don't have a list that I approve or don't approve at this juncture. You may want to ask your management company for a list of suggestions and then vet them yourself. I would strongly suggest that no matter which management company you're working with, they're probably not saying, here's one we approve. They're just like any other contract that they're working on for you. They're going to say, here's a list of a couple of people you should interview, investigate, and make a determination on your own. as the board. This is a board function to bring in a third party independent party. Got myself in trouble there.
And just to confirm, EJF does have a list for our Maryland clients already prepared, knowing that this came out October 1st.
There you go.
However, it doesn't trickle to DC and Virginia. So those of you on the line, keep this in mind.
Will you pop back to that slide just for one tiny thing down on the bottom? So this is, I mentioned this, but I want to highlight it. Unit owners and lot owners can qualify as long as they comply with the remaining requirements of the Condo or HOA Act, do not campaign or electioneer for any candidate, and are not subject to the objection more than 25% of the unit owners, the lot owners who are eligible to vote. So three things: they have to otherwise be eligible, they have to not be involved with any of the candidates, not have any ties to any of the candidates, and there's an opportunity, there's a rebuttable presumption here where if 25% of the voters say we don't want that person as an inspector, they can't do it. And then, so now we go to the next slide. And there was also another couple of small amendments to the Maryland Act recently. And it says that you can't charge for an owner requesting to examine the financial statements in person or receiving them electronically. So this was sort of a gulch there between the old statute where it said you could charge for making copies. And that was true when you had to put 10 cents into the copy machine per page and things like that. However, in order to just get digital copies, you can't charge for that. And associations can only impose charges to review or copy books of records when it's happening outside reasonable business hours or without reasonable notice. So if somebody demands to see it because they have to have it by tomorrow, that's the only time you can impose a charge. Otherwise, no charge is permitted. And
all right.
Where we are.
Thank you, Brian. We do have quite a few questions. So if you have a question, please drop it in the chat. You're not able to come off mute during these webinars, but I'm happy to read them out for my friend Brian. All right, so first one is, are we going to get a recording? Yes, everyone's going to get a recording. All of our recordings are actually on our website. So we did have a thrilling webinar back in August on budgets and the budget season and how to prepare. So if you missed that, check it out. But otherwise, we got a few years of webinars up there if you want to take a look. This is a great question. What happens if there's not enough board members?
That is a good question. Your bylaws are going to say something about vacancies, and I touched on this just a little bit, where if there is a vacancy and someone is volunteering to come and step into the shoes and serve in that spot, that the board typically fills vacancies until the subsequent annual meeting takes place. So you can appoint somebody in the interim. Now, the question I think is asking, what if there's nobody? Those vacancies are going to sit open, and you're going to want to consult with your attorney to determine what that means for the purposes of things like quorum and a vote. A lot of the documents say different things, and so I can't give a super broad answer in terms of what that says. Sometimes the documents will say a quorum of the board members is a majority of the sitting board members, and sometimes it'll say a majority of the total board members. And those two things can mean quite a bit different, right? If you've got a vacancy or even two vacancies, you've got an issue there. So the short answer is, I encourage you, if you've got a vacancy, to go out, recruit, put someone in that seat where possible. If you don't have willing board members, you're going to have decisions made by a smaller number of people, or they're going to be hamstrung and unable to make those decisions completely, and your association is going to suffer. So that's the short answer. For the specifics of your documents, you do need to consult with your attorney or look specifically at what they say.
In DC, is there a minimum number of months for short-term rentals?
Not by itself. DC doesn't have one. A lot of the governing documents I see have those provisions. And one thing to keep in mind when you're writing those leasing policies is a rental can be for a year, right? It can be for a year. And if that person stays there afterwards, that by law, if there's no continuation of the lease or anything else becomes month to month. So a lot of times what we suggest or advise to do is say your initial term has to be at least blank, whether it be 6 months or a year. Those are typically common ones where the board or the entire association has made a decision that they want to encourage and push for residential owners. But there is not a strict minimum set by DC zoning or anything else.
Nope. This is also another good one. Per the DC Condo Act, can the board establish a monthly fee for owners' use of common elements as personal storage? And I actually know this client, and they have an open room that has shelves, so it's not a private closet per person.
Yep. So we did talk about a while back in one of those slides that that is a function, and it is authorized by for the association to do to impose a charge for use of the common elements. If you've got a certain space and you want to rent it out, make sure you put forth a policy. And I've said the word policy quite a few times, but say, here's how we're going to treat it, whether it be first come, first served, whether it be everybody's got a pro rata per their percentage interest storage space or area that they might be able to access, or whether it be a sign up list or anything else like that. If you've got that space and you are going to utilize it for that particular purpose, that is generally approved by the Condo Act itself, and you want to make sure that you dot your I's and cross your T's.
Okay. Should the board or association do anything if owners rent their unit, but do not have a business license? Can the association be liable?
Just the lack of the basic business license by itself in does not provide a significant or does not create a significant risk to the association. And you should enforce like situations in like manner. So I didn't talk about this a lot because we were talking about composition and policies and things. But when you're going through your enforcement, you want to avoid selective enforcement. So if you're going after one person for the lack of a basic business license, go after all. Anytime you hear about it, go after them the same way. If you have decided as a board that just the lack of basic business license by itself is a DC problem and is a DC licensing problem, and so they need to deal with that, that is also a defensible position, but you have to, then you're stuck with that one. So if you've got an owner who is a pain in your neck for a bunch of other reasons and you want to use that as a pretext, you cannot do that. And I don't recommend it.
Mm. This is also a good one. You guys have a lot of good questions. Should condo docs be reviewed or changed or clarified? If so, how often? Our docs are from 1977 and could be clearer. I'm sure visually as well as text-wise.
Yeah. Some of them they're even scanned into the recorder of deeds like sideways or upside down, or they have some handwriting on them. The answer is very clearly yes. Regularly is the easy and nice vague answer. The statute changes a lot. And in the past couple of years, 2014, 2017, and 2021, I believe, there were pretty significant overhauls to the DC Condominium Act. For example, Maryland puts out some new stuff pretty much every year, and a lot of it is, groundbreaking or game changing, as the most recent one we talked about. So just that by itself suggests you should be reviewing or looking at your documents every year or every couple of years. Having your attorney review it or writing a new bylaw amendment every year. No, I'm not saying that. But you should take a look at it, make sure that you are generally in compliance with those documents, first of all, that you know what, if any, of those provisions has been superseded by statute, and then to clean them up. I would say there's no reason you can't do that every 5 years. If you're going more than 10 without really seriously considering a bylaw amendment, you're going to miss some stuff, and there will be plenty of opportunities for you to bring them up to date.
Yeah, there's definitely some big ones out there as far as involving insurance. If you still have that from 1977,
That's right.
Gonna cause you some problems. Okay, let's see. All right, our bylaws note that owners must vote on the budget. Should we seek to change that?
I didn't give a good enough my standard disclaimer at the outset. None of this is legal advice to your particular association. We are here for general concepts and guidelines. And so I won't opine on that one way or the other. I did state earlier that under the statute and under most bylaws I'm familiar with, the budget is a board level decision. And while owners get to be heard on it, they don't have to approve it. If your association decides that that would be a better situation for them or it would be easier to function, then they may want to consider it. But I won't go so far as to make a recommendation.
Fair point. Okay. What if you're the only one that's serving on the board? One person board.
I touched on this earlier, but your documents probably say something about quorum. You're going to want to look closely at them to say whether or not you are now a quorum of one, or whether you need more than one just to make quorum in the first place. My my suggestion, my urging to you would be to find some other people who want to be on the board and use your vacancy appointment and or have them come to an election, so that you don't end up in that function. If for no other reason, then it's not good optics. We talked about a little bit in there that unit owners have the ability to bring complaints and to file for violations of the bylaws. Well, if you're just the one person doing something, in my opinion, you're going to be a lot more likely to get some potential complaint, some potential aggrieved owner. Whereas if you have exercised the business, it's also tougher to make a record for the purpose of the business judgment rule. Still hold your meetings, but are you discussing something out loud with yourself? You can see how it gets very, very cyclical there.
Mm-hmm. Exactly. Well, Brian, thank you so much for your time today. Really appreciate it. Really appreciate all the board members that have taken time out of their busy schedules. I know you guys are volunteers, to attend. And yeah, I think we are wrapping up.
Well, thank you everybody for attending, and thank you very much, EJF, for hosting, giving me the opportunity to speak about some topics that I regularly deal with, and
Are very passionate about.
that's right.
All right.